So, hello, everyone. My name is Kseniya Kirichenko. I'm an international human rights lawyer, and for the past 2 decades, I've been working on international human rights law, specifically LGBTI human rights and family rights. So I'm really happy to be present at this conference online. Unfortunately, I was not able to come to Seoul, but I think that it's a really important event, and I hope that very soon we will see Korea joining a list of countries that have same-sex marriage. And as an international human rights lawyer, I can say that we have plenty of arguments, international and comparative human rights arguments to support same-sex marriage in Korea specifically. So my presentation is about marriage and family rights for same-sex couples from an international and comparative rights, human rights perspective. And of course, there is no kind of hard law, no convention that says that same-sex couples should have the right to marry, but we have a lot of jurisprudence, a lot of recommendations, a lot of discourses developed by international, regional, and national human rights bodies that really support the claim that same-sex marriage or marriage for all is a human rights standard today. So in my presentation, I will cover 3 areas. The first one is United Nations human rights standards and case law. Specifically, I will focus on the ICCPR, the International Covenant on Civil and Political Rights, then also Covenant on Economic, Social and Cultural Rights, and last but not least, CEDAW. So all the 3 instruments that have been ratified by Korea specifically. Then also I will go to the Inter-American Court of Human Rights and its groundbreaking advisory opinion on the same-sex marriage and family rights of same-sex couples. And finally, I will also go through some of the national jurisprudence, particularly Supreme or constitutional courts that have introduced same-sex marriage in specific countries or jurisdictions. So the first system is the global system, the United Nations Human Rights Standards and case law. And as I mentioned, I will focus on 3 frameworks inside the system, which is ICCPR, ICCPR, and CEDAW. So ICCPR, the International Covenant on Civil and Political Rights, and the Human Rights Committee that is monitoring implementation of this covenant. So this covenant has 2 articles that are important for us. Article 23, it's about the right to marry and to found a family. This article says that the rights of men and women of marriageable age to marry and to found a family shall be recognized. And then there is also Article 26 on non-discrimination. And even though the convention itself doesn't mention sexual orientation or gender identity, in a lot of decisions, in a lot of recommendations, the Human Rights Committee directly said that non-discrimination also covers non-discrimination based on sexual orientation and gender identity. So I looked through all the jurisprudence, all the case law of the Human Rights Committee while preparing for this presentation, and we can divide the jurisprudence that we are interested in into 3 areas or 3 steps. And then the early approach, the first step was, perhaps you've heard about this, it's the case Jocelyn versus New Zealand. It's a case of decision was made in 2002, meaning 23 years ago, quite a long time ago. And in that case, 2 lesbian couples from New Zealand went to the Human Rights Committee saying that, or claiming that no access to marriage for them in New Zealand was a violation of Article 23 on the right to marriage of the ICCPR. And then 23 years ago, the Human Rights Committee said that no, there is no violation because marriage is defined or described as a union between men and women, or the Article 23 of the ICCPR, unlike other articles of the Covenant, says not about everyone or human beings, but about men and women. So that was the interpretation 23 years ago. However, there was also a concurring opinion in this decision, and some of the committee members said that, well, even though maybe there is no violation of Article 23, still, it doesn't mean that different treatment of same-sex couples and heterosexual couples will never be a breach of Article 26, meaning equality. And then also what is also very important from my perspective is that one of the arguments that was used by the Human Rights Committee and by New Zealand in this case was that in 2002, there were really very few recognitions globally of same-sex couples. So there was no marriage in no country in 2002, and only a few countries recognized some types of unions or partnerships. So I think that if, and not only me, but also there are authoritative articles published on this, and we think that if the same case or similar case would have been considered right now by the Human Rights Committee, the decision would have been different. Because right now, of course, we have a lot of countries, around 40 countries in the world already recognize same-sex marriages. More countries are on their way. Many countries also recognize at least some type of unions between same-sex couples. So this argument would not play here anymore. Also, what is also important that this case was considered before a further jurisprudence, the second step of the jurisprudence of the Human Rights Committee, which were the cases about certain rights that same-sex couples were denied. And there were 3 cases against Australia and Colombia, 2 cases about denial of pension rights of same-sex couples, and 1 case about divorce rights, meaning that there was a lesbian couple that was married abroad, and then when they came back to Australia, they were not able to have access to a divorce because same-sex marriages at that time were not recognized. So in all these 3 cases, the Human Rights Committee said that it was discrimination under Article 26 of the Covenant, and the focus was made on reasonableness and legitimacy of distinctions. In other words, the Human Rights Committee said that, okay, so there were distinctions between same-sex couples and similarly situated heterosexual couples. There was a distinction, and there was no objective, proper reason for this distinction. Therefore, there was a discrimination. And then the last case that I think quite interesting, it's not about the right to marry, but it's a case about the right to possible conscientious objections of mayors or civil servants when it comes to officiating same-sex marriages. So in France, there was a group of mayors that were saying that the obligation to perform same-sex marriage ceremonies under the law was violating their right to freedom of consciousness or freedom of religion. And the Human Rights Committee said that, well, that's not really the case. There was no violation of Article 18 on freedom of consciousness. And the Human Rights Committee said that, well, there is a same-sex marriage in France, there is equality, and there would be no ways to really uphold fundamental rights and freedoms of same-sex couples unless they have really the right to be married. And then also the Human Rights Committee said that the lack of conscientious objections in this case was necessary and had a legitimate object, meaning upholding fundamental rights, upholding non-discrimination principle, which is in accordance with Article 26 on non-discrimination of the ICCPR. So even though this case is not about marriage per se, it says that, well, when it comes to equality in the context of family rights of same-sex couples versus freedom of religion or freedom of consciousness, the equality should prevail. So that's how we can interpret this decision. Then also, apart from this jurisprudence, apart from the decisions on particular cases, there were also recommendations to specific countries, concluding observations made by the Human Rights Committee when there were country periodic reviews. And the Human Rights Committee welcomed many states, specifically Chile and Greece, so not only global North countries, for introducing equal marriages. Then also, when it comes to concerns, the Human Rights Committee was concerned about lack of any recognition of same-sex families and couples in relation to, you can see, many different countries from different parts of the world. Also, discriminatory treatment of same-sex couples, inequality between marriage, heterosexual marriage, and same-sex unions or partnerships, and then also lack of access to marriage or bans on same-sex marriages. And recently, for example, there was a recommendation to India in 2022 for Japan, and many other countries as well. And so, based on this, the Human Rights Committee recommended states to specifically fully recognize or ensure equality of same-sex couples, to end discrimination against them, including with regard to marriage and family arrangements. Also, there were recommendations to ensure legal recognition and protection of same-sex couples without any discrimination, providing them all benefits associated with marriages, etc., etc. So then it was the Human Rights Committee, ICCPR. The next convention is the Covenant on Economic, Social and Cultural Rights that has Article 2 on non-discrimination that is also, according to the practice of the committee, is inclusive of sexual orientation and gender identity. There is also Article 10 on the protection of the family. And so here, again, concluding observations, there were concerns about lack of recognition of same-sex couples, and then also concerns that the existing alternative instruments were not providing equal protection to marriage. So same-sex couples didn't have the same rights as married heterosexual couples. Among the recommendation, we can see that countries were recommended to provide protection equivalent to marriage, to enact legislation on partnerships so that same-sex couples enjoy the same rights. And then also two Latin American countries, Panama and Honduras, were recommended to use the advisory opinion that we will look at a little bit later on non-discrimination in same-sex couples. And last but not least, so CEDAW, that is also ratified by Korea. CEDAW has two articles important here. The article number 1, definition of discrimination, general. So it's about discrimination against women, and as explained by the committee on multiple occasions in general recommendations, in case law, in recommendations to specific countries, it includes intersectional forms of discrimination, such as discrimination against women based on sexual orientation. And then another article, Article 16, which has a little bit different wording compared to, for instance, article on marriage and family of the ICCPR. So this is article about marriage and family relations, but it says about elimination of discrimination against women in all matters relating to marriage and family. And in the case Flammer Caldera versus Sri Lanka, it's quite a recent case still. It's not a case about marriage, it's about decriminalization of consensual lesbian relations, but still one of the parts of the decision was about interpretation of Article 16 of the Convention, and the committee said that this article also equally applies to non-heterosexual relations, and specifically same-sex couples. So in its concluding observations, CEDAW for several years already was saying that it's great when countries are legislating to recognize same-sex marriages, for example, in Argentina, in Switzerland, in Costa Rica. Then among the concerns that the committee was expressing in relation to different countries, many of them not from the global north, so there were concerns about the lack of legal recognition of same-sex unions and marriages, about practical or legal barriers that same-sex couples had in accessing marriage, about discrimination in rights and benefits, and also about the lack of assessment or implementation gaps. So in particular, in Liechtenstein, the committee said that it's great that you have same-sex partnerships, but the question is, do you protect same-sex couples who have access to these same-sex partnerships in the same way you protect marriages? And then, consequently, also the key recommendations to countries from CEDAW were to ensure legal recognition of same-sex unions and marriages, to adopt or amend legislation to guarantee equality, and also to monitor implementation and close equality gaps. So again, for the Liechtenstein, the committee said that it's important to ensure substantive equality in practice. So it's not enough that you just have a partnership for same-sex couples, but you have to ensure that they are really equal to heterosexual couples. And, well, all in all, when it comes to the UN human rights standards and case law, nowadays, what we have this picture of the development of standards throughout the time. We started from 2002 negative decision on Jocelyn, and then we went to the recognition and the recognition of the fact that states should recognize and protect same-sex couples in some way or form without any discrimination, to recommendations to eliminate discriminatory differences between heterosexual marriages and same-sex unions, and then finally to opening marriage to same-sex couples. So that's kind of the trajectory nowadays of the human rights standards and their development at the UN. And overall, there were also decisions, discourses formed, case law saying that non-discrimination and equality should prevail over religious or societal views when it comes to LGBTI human rights or marriage specifically. So then the next one is the Inter-American Court of Human Rights and the groundbreaking advisory opinion 2417. So it's the advisory opinion that was adopted by the Inter-American Court in 2017 based on the Costa Rica request to provide information about state obligations under the convention when it comes to same-sex relationships. So in this advisory opinion, the Inter-American Court provided two types of reasoning, and the opinion consists of two big blocks. The one is about what are the human rights that allow the protection of same-sex relations. And then the second block is about the practicalities, what type of mechanisms states should use to protect diverse families. So when it comes to the human rights grounding, the Inter-American Court said that treaties are living instruments, so we need to interpret the treaties in light of the evolution of societal beliefs, of political developments, etc., etc. So even though the right to same-sex marriage is not written per se in the convention, directly, explicitly, we need to interpret the convention in the light of current developments. Then also the Inter-American Court said that recognition of same-sex family ties is protected under Article 11 on privacy, 17 on family, and then also equality of the American Convention and their sister articles in the UN system. So also the Inter-American Court looked at the provisions of the ICCPR specifically and said that, well, there are also similar provisions that protect same-sex family ties. Then also the court said that there is no strict definition of family, and it should be inclusive of emotional ties in same-sex couples. And, well, last but not least, it says that there should be protection without discrimination as regard to heterosexual couples, and three groups of rights should be protected for same-sex couples. So first of all, it's patrimonial or property rights, but then also internationally recognized human rights, and all the rights and obligations recognized under the domestic law for heterosexual couples. In other words, if you provide heterosexual couples with the right to adoption, the same right should also be provided to same-sex couples. And then also the second part of the Inter-American Court's advisory opinion was about practicalities, the mechanisms that states could use to protect diverse families. So the Inter-American Court said that, yes, there is no single model. Different countries use different models. They introduce different institutions. Sometimes it's, for example, civil union or registered partnerships. Sometimes it's same-sex marriage. But importantly, the court said that civil union is not equal to marriage. So just providing civil union or registered partnership is not enough for states to implement all their human rights obligations. Why? Because first of all, there is no acceptable purpose for differentiation. We cannot find a single acceptable reason why heterosexual couples have access to marriage and homosexual couples, same-sex couples, don't. Because procreation or religious or cultural convictions cannot justify such a difference. Then also the court said that when we have a situation, when we have registered partnership or union with all the same rights and benefits as the marriage, but the only difference is the name, is discrimination, because the only thing that we are doing through this situation is creating stigmatizing label. So we singling out certain group of people, and then we say that they're less than. Therefore, states must ensure access to all legal institutions in their domestic laws to protect all the rights of same-sex families without discrimination in relation to heterosexual families. In other words, yes, you can have registered partnership and marriage, but both institutions in this case should be available to both same-sex and heterosexual couples. If you have heterosexual couples access to marriage, which all the countries have, you also have to provide the same access to same-sex couples. And even when time is needed to adapt to these standards, so, for example, you need to go through certain parliamentary debates to enact a law on same-sex marriages. Even during this time, this transitional period, EU states are obliged to ensure to same-sex couples equality and parity of rights. And then also the last part of my presentation, it's about national jurisprudence. Of course, there were a lot of cases, and some of my colleagues later will talk about, for example, brilliant decisions from Japan, for example, and also reasoning that have been used by other courts. But I want to just go quickly through 4 decisions from different jurisdictions. So there was a case the Supreme Court of the US in 2015. There were also cases from countries from the Global South. There was a Mexican court, there was a court in Ecuador, and then also Aruba and Curacao. So all these cases, they provide in a way similar reasoning. For example, the US Supreme Court, it said that the 14th Amendment due process clause required all US states to introduce to license recognized marriages between same-sex couples, because marriage is a fundamental right. Equal protection and dignity apply equally to same-sex couples. And also, similarly to what we've seen with, for example, the Inter-American Court, constitutional interpretation evolves with social understanding. In Mexico, also, the Supreme Court of Justice said that it's not okay to prohibit basically same-sex marriages, saying that the purpose of marriage is procreation, or that the marriage should be defined as only an act between a man and woman. It's unconstitutional because we cannot link marriage to procreation. It would be unjustified discrimination. Also because heterosexual couples are not always procreating by will or by the situation. And then also sexual orientation cannot be a legitimate ground for exclusion. In Ecuador, the Constitutional Court again said that same-sex couples have the constitutional right to marry based on the interpretation of the Constitution in light of equality and international human rights obligations. So the Constitutional Court said that the advisory opinion that we know already about was integrated into constitutional interpretation, that equality, dignity, and again, evolutive interpretation of the right, gendered defined marriage, that there is no compelling justification for excluding same-sex couples from accessing marriage, and that state must protect families in all diverse forms. And the last decision, last piece of jurisprudence, it's about Aruba and Curacao and their joint court of justice that said also that excluding same-sex couples from marriage is discriminatory and unconstitutional, and marriage must be open to them. So again, the court said that traditions and symbolic arguments are not legitimate justification for the difference. They also said that registered partnership is not a sufficient substitute for marriage. So you cannot just give same-sex couples partnerships, but not the marriage when heterosexual couples have access to marriage, because marriage carries symbolic, emotional, and intrinsic value and provides more legal protection and stability. And then also exclusion violates constitutional equality. So overall, if we look at the UN human rights standards, at regional standards of the inter-American system, at the different various decisions from national jurisdictions, we can see that marriage equality actually follows from international human rights law. Moreover, civil unions just providing same-sex couples and alternative instruments like civil unions or registered partnership is not fully equality. And last but not least, we see also the forming global legal consensus that exclusion of same-sex couples from marriage is unjustified discrimination. And then to end my presentation, I just wanted to give you one quote from the advisory opinion of the Inter-American Court, which said that it's not downplaying other family models, nor it is ignoring the importance of the family institution as an essential component of society. To the contrary, the court is recognizing the same dignity to the emotional ties of a couple formed by two persons who are part of a historically oppressed and discriminated minority. So actually, when we talk about equal rights in marriage, we are not talking, we don't want to diminish family, to destroy family institution, to go against the society, but actually we want to be a part of society, a legitimate part of society. And I believe that Korea could really join the list of countries with marriage equality, and through this demonstrate to the whole world that it is important that equality, that family is actually a value that is important for everyone. Thank you.